Yeah, a little bit. We don't want to get too far behind. I'll make it. If we get too, if we do, I'll get make it up in a break or something. Break sometimes too long. We'll get right back in a break after the first part. No, after the. Good morning to everyone. It's obvious this is similar to church. They start seating at the back and work forward. So we've got a lot of empty seats in front, but this is not church, so the folks in the back are more than welcome to come to the front. Good morning, and I'd like to begin this morning by recognizing on September the 11th, 2019, remembering the attack on American soil, September the 11th, 2001. Where over 3,000 were killed and more than 6,000 injured. The attacks were the deadliest terrorist attacks in world history and the most devastating foreign attack since Pearl Harbor. That day we lost 343 firefighters, 72 law enforcement officers, 55 military personnel. Those attacks touched and are still touching lives across our nation. Some of you here today were at the Pentagon and witnessed firsthand the devastation. On December the 8th, in 1941, President Franklin D. Roosevelt stated, "Yesterday, December 7th, 1941, a date that will live in infamy, the United States of America was suddenly and deliberately attacked. An unknown author on September 11th, 2001 stated, "We shall never forget. We shall keep this day. We shall keep the events and tears in our minds, our memory, and our hearts, and take them with us as we carry on." Events today in New York, Arlington, Pennsylvania, how fitting is it that we meet today, September 11th, 2019, to remember this day. This past session in the General Assembly, a joint resolution was passed recognizing September 11th as First Responder Day in Virginia, of which you will hear more about later. September the 11th, 2001, another day that will live in infamy. Please rise for the presentation of colors. Please remain standing for the invocation led by Sheriff Ashton Fulton of Louisiana County.
At this time, they have a moment of silence, reference to 9/11. Amen. Let us pray. Our Father, which art in heaven, Hallowed be thy name, thy kingdom come. Thy will be done on earth as is in heaven. Give us this day our daily bread, and forgive our debts as we forgive our debtors. And lead us not into temptation, but deliver us from all evil. For thine is the kingdom, the power, and the glory. Father, Lord, we ask you this day to continue to bless the Virginia Sheriff's Association. Bless those that also that are gone ahead of us. Father God, we pray this morning that you bless the administration of this organization. Bless all sheriffs that are present. Bless their localities, what they represent. Father God, we pray that you bless the vendors that have put on this association. And we give your name the glory and the praise. Bless the motel accommodation. As we go through this day, O Lord, whatever be said or done, let it be pleasing in your sight. In Jesus' name, amen.
Join me in the Pledge of Allegiance. I
Pledge allegiance to the flag of the United States of America, to the republic which stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you very much, and be seated, please. Now for our official welcome. It is my absolute pleasure and honor as your president to extend a warm welcome to you and the members of the Virginia Sheriff Association, friends and guests, to our 86th annual conference. The Virginia Sheriff Association staff has worked extremely hard, tirelessly, to provide a lot of opportunities for you to network with other sheriffs and deputies, and you invited many special guests and great speakers, and you will not want to miss an informational, educational opportunity here this next few days. Be sure to visit our exhibitors. It is because of them that we are able to provide a first-class conference, so when you see them, stop by their tables just to say thank you. Last night's reception was sponsored by Medico. And Dr. O is here with us, and we'd ask Dr. O if you would please stand and show him appreciation for last night's reception. Dr. O and members of his staff, thank you again. Also, while you're here in Williamsburg, please take the opportunity to explore the Williamsburg area. There's a lot of rich history with a lot of family activities. It was interesting last night, someone asked my wife, was there a mall in Williamsburg? And she looked, absolutely it's not a mall. They have maintained that historic value without a mall. Good for them. Be sure to thank Sheriff Robert Dees and his staff for doing such a great job hosting our event, along with Doubletree Hotel by Hilton. So best wishes for a wonderful conference, and thank you for allowing me to serve as your president. Let's have a great conference. That is indeed a pleasure at this time to continuation of our recognizing our 9/11/2001 Chief Deputy David Harden, Williamsburg, James City County Sheriff's Office.
Good morning and welcome everybody to Williamsburg. My sheriff sends his regards and wants to thank everybody for coming. And we are actually in James City County. But our sheriff takes care of Williamsburg and James City County. I appreciate the plug for Williamsburg while you're here. We definitely could use your money, so make sure you spend lots of it. We do have quite a few things around here. If you get the opportunity to go to Jamestown, historic Jamestown, also maybe the Yorktown Victory Center, and some other shopping there is around here. We do have stores, we just don't have malls. I have the honor and distinct pleasure to introduce our delegate of the 93rd District, Delegate Michael Mullen. He represents Newport News, Williamsburg, James City County, and York County. He is in his first year of legislator. He actually sponsored 4 bills that passed, and that was actually the most of the freshman delegates that in their first year. He served on the Counties, Cities, and Towns Committee and the Courts of Justice Committee. And in his second year, he was reappointed to those. He also, in his second year, sponsored 4 more bills that passed. And then he was appointed also to the Commerce and Labor Committee. He was also served on the Committee on School Safety through 2018, and he is, as all delegates and senators this year, is on the ballot for re-election. When he's not up in Richmond, he actually is a Commonwealth Attorney in Hampton. He is also a resident of Newport News. He went to college in Newport News. That's what brought him here. And without further ado, represent Delegate Mike Mullins.
Well, thank you all very much for being here in Williamsburg and James City County. As it was said before, please spend money. I want to take an opportunity first to be able to thank everyone here in the Sheriff's Association, John, President Dempsey. Sheriff Fortune, that was a lovely invocation. Thank you very much for leading us in prayer. And Chief Deputy Hardin, it's always wonderful to be able to be with you. Today, on September 11th, we have the opportunity to be able to honor, commemorate, and remember. First, I would say that we would remember the 653 first responders who have died in the last 5 years. 653. In fact, a third of those are fire and EMS, and the remainder were law enforcement, all of whom died protecting their community and doing so much in the highest calling that one can have. We commemorate those who have served their entire careers as first responders. That is a tremendous service. And, I say service because, there are lots of those of us who serve. We have teachers and nurses, prosecutors. We all serve. But there's a higher service that comes from being a first responder. There's a higher service that comes from being in law enforcement. I don't know about anybody else here, but I always grew up watching Mr. Rogers' Neighborhood. Fred Rogers was a real hero of mine, actually. And he said after September 11th that what he said to all the kids who were so terrified after that, he said, in times of great tragedy, look for the helpers. Look for those who are helping others. Every night I say to my 3 young boys, what did you learn today? And what did you do for someone else? In times of tragedy, we look for those who run towards danger, not for those who run away from it. People who take the 1,980 steps up the Twin Towers, as they did 18 years ago today, making the ultimate sacrifice that we remember. Coming up to today, I've been listening to a lot of Bruce Springsteen. There's an album called The Rising, and there's a song in there that talks about it being a fairy tale so tragic. And in the 18 years since 9/11, we've sort of created a fairy tale about 9/11, about the people who have served there. But it's important to remember that those are real men and women. Those are real people who made the ultimate sacrifice. These are people who like to fish, like to barbecue, tell dirty jokes, maybe have too much to drink on a Saturday afternoon. These are real people. These are our friends. These are the people that we serve with who, on that day, that morning, made the ultimate sacrifice, as did the 653 in the last 5 years of our colleagues and friends who did the same. So I would say it's probably fitting that we're here in Williamsburg and James City County on today, where 412 years ago, normal people like you and I came here and made a great sacrifice to be able to found what would become this great country. And 400 years ago, normal people like you and I chose to found representative government only about 6 miles from where we stand today. Here in Virginia, we're actually the heir to that General Assembly that has been continuously operating as the first representative government in the Western Hemisphere for 400 years. And while it is a little bit bigger than the 23 people who arrived on that day, we still get a few things done, at least every once in a while. We're unlike Washington, D.C. There's a reason that we keep a river between Washington, D.C. and us. We're not very partisan like they are in D.C., and, you know, every once in a while we can get something done, like what we've done here today, which is that we have designated September 11th on this year and every year following as First Responders Day. All 140 members of the Virginia General Assembly from all parties, all walks of life, all areas of the Commonwealth came together to be able to honor our first responders, those who put their lives on the line every day when it's making a traffic stop, when it's responding to a domestic call, when it's serving process, when it's protecting those who have overdosed or have had a heart attack. All those brave men and women in our public service, in our highest service, who respond in our emergencies. And so today, I'd like to be able to present John and Sheriff Dempsey this resolution from the Virginia General Assembly commemorating today and all day forward on September 11th as First Responders Day. Well, usually we don't read all of these all together because there are a lot of where is and where tos and some very fancy language. But I did want to read this one section to y'all. So resolve further that the clerk of the House of Delegates transmits copies of this resolution. And I want to specifically note that we are talking about the Virginia Department of Fire Programs, the Virginia Department of Health Office of Emergency Medical Services, the Virginia Association of Volunteer Rescue Squads, the Virginia Association of Governmental EMS Administrators, the EMS Regional Directors Group, the Virginia Ambulance Association, International Association of Arson Investigators, the Virginia Chapter, Virginia State Police, the Virginia Sheriff's Association, the Virginia Association of Chiefs of Police, the Virginia Fire Chiefs Association, the Virginia State Firefighters Association, Virginia Professional Firefighters, Virginia Department of Emergency Management, the Virginia Emergency Management Association, and the Virginia National Guard, so that first responders in the Commonwealth may be apprised of the sense of the General Assembly, and that the General Assembly from this day forward commemorate September 11th, 2019, and each year succeeding as First Responders Day in Virginia. You know, I just as a little, you know, how the sausage is made sort of story, when John and I were talking about making a day First Responders Day, you know, there are about 20 organizations that we just listed right there. And every one of them wanted it on their anniversary, everyone wanted it on their birthday or their national day. And then we spent 7 months trying to be able to convince everybody on what day, you know, we had a lot of meetings actually, on what day we were gonna, some people wanted it on Christmas, they wanted it on their national day. And finally, John had the right idea and said, well, what about September 11th? And nobody disagreed with that one. That was the one day we could all agree on. So I appreciate everything that y'all do, and thank you, and welcome to Williamsburg, James City County.
Delegate Muggins, thank you again, and members of the House and Senate for remembering us, and certainly we do appreciate your resolution. Sheriff Vanessa Crawford. There she is. And Sheriff, the last time we were here together, I think you were sworn in as president. And that was a day that we'll all remember. You had quite a support group here with you. So I'd like for you to introduce our next panel, if you would say. Thank you very much.
Good morning. I have the privilege of introducing our next panelists. First, are they going to be joining us up here? As I call their names and introduce them, they can join us up here. First, I'd like to introduce Jared Adams. Jared was wrongfully convicted of sexual assault at the age of 17 and sentenced to 28 years in a maximum security prison. After serving nearly 10 years and filing multiple appeals, Jared was exonerated with the assistance of the Wisconsin Innocence Project. Jared used the injustice he endured as inspiration to become an advocate for the underserved and often uncounted. As a first step, Jared earned his Juris Doctorate from Loyola University Chicago School of Law in May of 2015 and started a public interest law fellowship with Ann Claire Williams, judge for the Seventh Circuit U.S. Court of Appeals. This is the same court that reversed Jared's conviction because of his trial lawyer's constitutional deficiencies. Jared's remarkable story has captured both local and national media attention. At one point, hashtag Jared Adams was trending on both Facebook and Twitter. As adjunct professor at the Loyola University Law School from 2014 to 2015, Jared is a recipient of the 2012 Chicago Bar Foundation's Abraham Lincoln Marovitch Public Interest Scholarship. He also won the National Defender Investigator Association Investigator of the Year Award for his work with the clemency petition of Reynolds Wintersmith, ultimately granted by President Obama. Going from inmate to exoneree to law student to law fellow, Jared has a unique perspective to share. A thought leader in those areas, Jared continuously contributes to the ongoing discussion around prison reform and wrongful convictions. Jared joined the Innocence Project's litigation department as the department's first post-conviction litigation fellow in July of 2016. Prior to joining the Innocence Project, Jared co-founded a not-for-profit called Life After Justice, geared toward advocating for the rights of the wrongfully convicted once released. His story of incarceration, exoneration, and redemption has been featured widely in the media, and he has become a sought-after motivational speaker for athletes, students, inmates, attorneys, and others. Let's welcome Jared Adams. The next panelist that I'd like to invite to the stage, Mr. Stephen Benjamin, is the founding partner of Benjamin and Deportes. He also serves as special counsel to the Virginia Senate Courts of Justice Judiciary Committee and is a member of the Virginia Indigent Defense Commission. He is a past president of the National Association of Criminal Defense Lawyers, a fellow and director of the American Board of Criminal Lawyers, a past president of the Virginia Association of Criminal Defense Lawyers, and a fellow of the American Academy of Forensic Sciences. Mr. Benjamin was counsel in the landmark Virginia Supreme Court decision recognizing a constitutional right to forensic expert assistance at state expense for indigent defendants. In other cases, he argued through the trial courts and on appeal that Virginia's mandatory fee caps on compensation for court-appointed counsel-deprived indigent defendants of conflict-free representation, and he led the litigation and legislative effort to abolish those caps. At the request of the Virginia Supreme Court, he helped establish and chair an annual advanced indigent defense training seminar to draw top lecturers from across the country to train Virginia's defenders at no cost. With his law partner, he won the non-DNA exoneration and release of a man serving a life sentence for a murder that he did not commit, and he argued in the United States Supreme Court that a Richmond trespassing policy violated the free speech rights of public housing residents. He assisted the State Crime Commission in the creation of Virginia's writs of actual innocence, and after determining that criminal defendants throughout Virginia were routinely losing their appellate rights because of attorney error, he helped draft the procedure that was enacted by the Virginia General Assembly to restore those rights. When biological evidence was discovered in 20 years of old case files stored in Virginia's crime laboratories, he helped persuade state political leadership to order statewide DNA testing. When the pace of that testing stalled, he worked to obtain the passage of 2 successive bills mandating effective notification of interested parties that this new evidence had been discovered. He is a recipient of the Virginia State Bar's Lewis F. Powell Pro Bono Award in recognition of his years of indigent defense and efforts toward indigent defense reform. He is a frequent lecturer on criminal justice and defense issues. Let's welcome Mr. Benjamin to the stage. Mr. Michael Doucette, please join us. Mike Doucette joined the Lynchburg Commonwealth Attorneys in 1984 as an assistant Commonwealth attorney and was a Commonwealth's attorney for Lynchburg from 2006 to 2017. He became the first executive director of the Virginia Association of Commonwealth Attorneys on January 15, 2018. Mike graduated in 1981 from the University of Connecticut and in 1984 from the Marshall Wythe School of Law at the College of William and Mary. In 2003, Mike was honored by VSA with the Von Schuch Award as the Outstanding Assistant Commonwealth Attorney for the entire state. In 2005 and in 2011, he received the Lynchburg Police Department's Honorable Service Award. In 2011, Virginia Lawyers Weekly chose him as one of the 31 honorees for the Leader of the Law. In 2014, he received the VACA's Robert F. Horan Jr. Award as the Outstanding Commonwealth's Attorney for Virginia and the Virginia Association of Chiefs of Police President's Award. In 2017, he received VACA's Micah R. Doucette Award for Lecturers of Merit. Mike is a past president of VACA, and he previously chaired the Protective Order Subcommittee of the Governor's Domestic Violence Prevention Advisory Board, as well as the Virginia Criminal Justice Services Board. He has served on the Virginia State Crime Commission, the Virginia Supreme Court's Special Committee on Criminal Discovery Rules, the Virginia Criminal Justice Conference, and as president of the Board of Directors for the Virginia Legal Aid Society. He serves on the Board of Governors of the Criminal Law Section of the Virginia State Bar and on the Virginia Supreme Court's Model Jury Instruction Committee. For many years, Mike has been a frequent faculty member for the Commonwealth's Attorneys Services Council and the National College of District Attorneys. He's a Cold War veteran of the United States Air Force. He lives in Lynchburg with his wife, Beth, and Beth and Mike have 4 grown children and 5 grandchildren. Let's welcome Mike. And finally, I'd like to invite Ms. Betty Lane Desports to the stage. Betty Lane received her JD from the University of School of Law and her master's in forensic science from Virginia Commonwealth University. Betty Lane is a past president of the American Academy of Forensic Sciences and a fellow of the American Board of Criminal Lawyers. She serves as chair of the Forensic Sciences Foundation, Incorporated, and on the American Bar Association's Task Force on Biological Evidence as a representative of the National Association of Criminal Defense Lawyers. She also served on the ABA Task Force on the presentation of forensic science evidence. She has actively sought reform on Virginia's indigent defense system and is committed to improving indigent defense forensic resources. In 1996, Betty Lane and her law partner, Stephen D. Benjamin, obtained a landmark Virginia Supreme Court decision recognizing the constitutional right of an indigent criminal defendant to expert forensic assistance. Since 2005, she has assisted with speaker recruitment and planning of the Virginia Chief Justice's Advanced Indigent Criminal Defense Training Seminar. In 2001, Betty Lane and Steve obtained the exoneration and release of Jeffrey David Cox a man who was serving a life sentence for a murder he did not commit. Let's welcome all of our panelists to the stage.
So apparently I'm up first. Good morning, everyone. I guess I'll start by saying this. I am thankful to be here in the presence of so many wonderful people this morning. I think that that our system needs to have more of this. And what I mean by that, more of this, is we have to find a way to move out this adversarial setting that we have in our criminal justice system. It's the only way we get to equality. So I am thankful that I am here. I was 17 years old, born and raised on the south side of Chicago, and I used to routinely hook up with a group of friends. We would go outside of the neighborhood, and we would try to find fun outside of the neighborhood. And the reason we would do that is because there was so much violence that plagued the south side of Chicago. I can't sit up here and tell you that I have a story of being in the streets and I was a gang member and shooting and selling drugs. I find those stories fascinating. When I hear guys tell a story and they change their lives and they come back around, that wasn't my story. I had a story where I grew up in a house where there was always someone there. You know, back in the day when you do something wrong, you get a whooping by your auntie, and then your mother comes home and she whoops you, and then dad comes home and he gets you, you know, the good old days, right? So my grandmother kept all of us grounded. I came from a huge family, quite actually. My grandmother and grandfather had 6 girls and 3 boys. So it was a large family, a lot of nieces and nephews, and I was the youngest grandchild. So when I tell you that I wasn't in the streets, it wasn't because I just thought it was a good idea to stay out of the streets. I was grounded by my grandmother. I was grounded in the knowledge that they came from Jackson and Cleveland, Mississippi, and they snuck my aunts and my uncles out of Cleveland, Mississippi, where technically slavery had ended, but people were still in the fields. And my grandfather wasn't, you know, I wouldn't call him a scholar, but he was a very, very smart man. He sought refuge with his cousins in Chicago, and he came up from Mississippi, and he worked until strategically he was able to bring home each and every one of his kids, and lastly, my grandmother, his wife, from down in Cleveland, Mississippi. No sooner than he got my grandmother up, he was drafted into the war. You're talking about a man who was in his mid to late 30s with about 9 kids. And somehow, as soon as he got his wife and his last kid out of Cleveland, Mississippi, he was drafted into the Army. He went into the Army. My mother wasn't born yet. He went into the Army, he caught a bullet, and he almost died on the beaches in Normandy. In fact, he came so close to dying that they flew my grandmother from Chicago over to Germany to go and see him. Not Germany, I'm sorry. They flew my grandmother overseas to go and see him, and they thought he wouldn't survive. He had a bullet that was still stuck inside of his chest, and they thought that it would move any day and he would, you know, pass away. He came home back to Chicago. He was able to recover and get back home to Chicago. He made it home, and they told him, they said, look, take it easy. You know, this bullet can move any day now. In its process of taking it easy, my mother was born. So he stuck around long enough, and I thank him for being so strong, because without him and that, I wouldn't be here. So I gave you that background to let you know that sometimes our criminal justice system will paint a person as if they were born right on the spot of their accusation. So there was a method behind me explaining to you my background and where I came from, so you guys can understand that I'm not the only case where the criminal justice system can get it wrong. I was falsely accused of a sexual assault along with 2 other friends that I went to this party with from Chicago. And it wasn't a close call at all. It was an absolute lie. And the authorities had part in this entire allegation. I ended up being sentenced to serve 28 years in prison. Couldn't afford an attorney. And I remember not an act of violence while I was incarcerated. I remember the wrinkles and the creases of anguish that lined my mother's forehead, because I know I didn't commit any crime, but I knew good and well I didn't have any business sneaking in the car, going to a party overnight, and I was burdened with that my entire time that I was incarcerated. When I got to prison, I started to write as many people as I could. I was encouraged by a cellmate. It was an older white guy who was serving he was serving 20 years to life or something like that. He had been down for about 18 years already. He encouraged me to stop playing basketball, stop playing chess, and to look at my case. See, I wasn't playing basketball and playing chess because I didn't care about my life. I was doing that because it was therapeutic. And I didn't want to have to deal with the fact and think about the fact that I was 18, turning 19, with a 28-year sentence and a mandatory release date of February in 2019. I was encouraged after having a conversation with this older man who had been doing so much time and spent so much time in prison. And I started to strategically go through my transcripts, my paperwork, and I located a witness that I just wasn't thinking about that night. And I was able to contact the Wisconsin Innocence Project with this witness. They were able to locate this witness, and it unraveled my entire conviction to where we found out that this wasn't the first knowledge about this witness in my case. The authorities said that they mistakenly misplaced the statement. If you believe in that, you also believe in Santa Claus, the Easter Bunny, and all of those other things, right? I ended up being in prison from 1998 until the Seventh Circuit reversed in order that I be released in 2007. And I was thinking, I guess, that I would be apologized to or paraded around the courtroom as an innocent man, like I was paraded around the courtroom as a monster in front of my mother and my aunts. In the blink of an eye, my conviction was reversed. The judge slammed her gavel. His record is expunged, and that was it. And I turned around to that same lady with those wrinkles and creases of anguish, and I promised her we were done crying. And I left out of that courtroom, and 30 days later, I enrolled in junior college. My mother had moved from the south side of Chicago out to a nearby suburb, and from her couch and on foot, I walked, and I got my first degree. After that, I was inspired. I got my second degree, and I got employment as an investigator at the Federal Public Defender's Office in Chicago. There, I was able to interact with the same Seventh Circuit that overturned my conviction, where I was able to gain a relationship with a judge named Judge Ann Claire Williams, and she afforded me the opportunity to clerk in the same court that overturned my conviction. I kept feeling that as soon as I got my degree, as soon as I was an attorney, that I would be fulfilled. That wasn't the case. It wasn't fulfilling to me. And I was reminded of that when I went to my mother's house after my diploma had came into the mail. And I handed it to her, and she's crying. And I said, look, I thought we were done crying. And she says, no, I'm not crying because I'm sad. I'm crying because I know you'll have the opportunity to keep another mother, to keep another son from experiencing what you've experienced. And I took that as a sign, and I woke up again. And I went on and I took and passed the New York bar. I applied for a position at the Innocence Project where I was accepted, and I worked there for 2 years. And I was a part of the exoneration of a man who had spent 30 years in prison in Wisconsin based on the testimony of a hair that, during the times before technology had advanced, we would believe the science that we all had to rest on, which was usually people's years of experience. There was a hair, there was an agent testifying that this hair looked like the same hair from the crime scene that was on my client's head. Years later, we did DNA testing, and 99.9% sure it was not his hair. His conviction was reversed. And for the first time, I learned something. You see, I immediately thought this was a racist, racist system, right? My client was white. I was black. And it humbled me. And it made me realize that this is a classist system first. If we were all one color, the system would eat up the people who couldn't afford. That's what it would do. So how do we level the playing field? We level the playing field by having real conversations like this, not pointing fingers, not pitting sides, because you can have whatever contest that you want. If you pit sides against one another, our competitive juices will flow, and we will want to do what? Win, right? We have a system right now that backs what I'm going to say to you. We have a system that believes more in finality than it does justice. It isn't an indictment on one party. It should be a wake-up call to all parties. We are losing a talent pool. Do not think for a second that I made it to the Department of Corrections and I suddenly swaddled a smart pill where I was able to learn how to do the LSAT and go and pass the bar and stuff like that. That's not the case. I had this talent that I was born with, and there are so many other talented people that we are wasting away in the system. And if that doesn't reach you, maybe it'll reach you another way, right? Maybe we are locking up that one bright mind who has is just on a cusp of being able to come up with some drug that might cure cancer or contribute to society in such a way that it benefits us all. There's a way in which we have to start humanizing what we're doing in our criminal justice system. We have 2.3 million people incarcerated today in our society. We can't call ourselves the greatest nation in the world and be the greatest incarcerator in the world as well. There are countries who have a total, men, women, even children, of 900-something thousand people who are incarcerated. We have roughly 800,000 black men who are incarcerated. There's a balancing to this ecosystem, right? And let me tell you, another thing that scared me to death being in prison, again, it wasn't a stabbing, it wasn't a beating or anything like that. I'm on a visit, and I was on a visit with 3 guys that I played basketball with, and they were calling each other nicknames and stuff like that. Everybody had a nickname, right? So I thought when they were calling each other old man, G-son, and all that type of stuff, I thought they were street nicknames from blocks that they all grew up on. I didn't realize until I was on a visit with my mother that this was a grandfather, a father, and a grandson in one prison, not on the same case, non-violent drug offenses. And quite frankly, I believe one of them was there for selling marijuana. And whenever I go back to my wife's hometown in Detroit, they got marijuana dispensaries popping up everywhere. That is a slap in the face to not just those who are incarcerated, but to all of us, all of us on the ground. You guys are on the ground. And you're dealing with a system that is a cycle. If we were getting any better and any safer in society by locking people up, we could still leave our front and back doors open. But we're not there. So I am going to close and save some for my 4 o'clock session, but I'll just say this. We can't expect to warehouse people for decades in animal-like conditions, treat them like animals, and then tell them, when we release you, now you go be human. That makes absolutely no sense at all. Reentry is something that I am a big proponent of. In fact, I met Sheriff Crawford on several different occasions, and one in which she had a reentry summit. That is one of the fastest and surest ways to make sure that we combat what is going on inside and outside of our criminal justice system. When people go inside of prison and they spend so much time there, they aren't usually given any programs until they're getting ready to get out, right? So it may be 6 months, 8 months, probably 12 months until they're getting ready to get out, and then they're given all of these reentry programs. Well, let me use this analogy. Imagine if a parachuter decided, I really don't need to put this parachute on until I get ready to jump out this thing, right? Now, some of them might make it, They might be able to put it on their way down, right? But the majority of them will bounce off the ground and it just won't work. That's exactly what we're having in our system. And this is me telling you from both sides of the fence that this is affecting our entire community as a whole. We have allowed for different classes to be treated differently in our society, and now it's trickling down. There used to be a crack epidemic where we had a war on drugs. That war on drugs resulted in a war on incarcerated, in mass incarceration was the result of it. Now we have an opioid crisis, and now I'm seeing commercials of how to treat it, and it's an issue and stuff like that. We have to do better, and it's all on us. It ain't on somebody, it ain't on them, it is all on us. Our voices have to ring together. I'm on the ground. Everyone in this room today is on the ground. We are the ones who deal with the laws that are enacted. We are the ones who deal with the community. So we all have to voice our opinions together. We don't have to agree on everything. And I'm not sitting up here telling you that we don't need a criminal justice system, we don't need prisons, but what I'm telling you is this. We cannot call it the Department of Corrections if we are doing nothing more than warehousing people. Thank you guys for your time.
My name's Betty Lane Dasports, and Steve Benjamin and I work together on everything, and so you may hear him pipe over every now and then with a tidbit, and when he stands up, I'm going to do the same. We have experience with correcting several wrongful convictions, and we represented many innocent people. And one thing that I can tell you, two things that I know for sure, that generally a wrongful conviction isn't the result of an evil mastermind. It isn't someone wanting to convict someone. Okay, thank you. It's not an evil villain wanting to convict an innocent person. Generally, what happens is within the system, a whole lot of people are doing their job, sometimes poorly, sometimes fine, but not great. And it's generally a cascade of small errors and missed opportunities that lead to a wrongful conviction. And these are errors by defense attorneys, prosecutors, judges, jurors, law enforcement. Everyone along the line usually has an opportunity to correct or to stop a conviction from happening of an innocent person, but something goes wrong. We look the other way, we're busy with another case, we have, other things going on, we're getting pressure to solve the case, too much work of a workload, that happens a lot. And so what happens is there are opportunities that are missed, and someone is wrongfully convicted.
When we talk about failures within the system leading to the conviction of an innocent person, my own feeling is that and I want to be very clear about this, I believe that the ultimate person responsible for that failure is the defense attorney, because I view the defense attorney as the safety net that has been placed within the system. There will always be human error, no matter how hard we try within the system, no matter how hard you try, how hard the prosecution tries, how faithful to science the forensic scientists are, there will always be flaws. There will be missed investigations. And I view the defense lawyer as the one ultimately responsible when something goes wrong.
But that's not to say that everyone along the line in the criminal justice system doesn't have a responsibility. So we know that from working with these cases. The other thing that we know is that fixing a wrongful conviction is incredibly difficult. The law is against the person. There are too many procedural hurdles. One thing in Virginia that you have to keep in mind is that we have the 21-day rule. And it's based on a rule of court that says 21 days after the judge signs off on that sentencing order, that final judgment, it is completely final. 21 days after, you cannot introduce new evidence. It's over. And once that finality is in place, that is the biggest hurdle. And so there, with the 21-day rule, it just doesn't stop is the other thing. The countdown keeps going. You can't stop it with motions. You can't stop it with orders. It just keeps going. All of these things, you're done. So the best way to correct a wrongful conviction is to prevent it. And that's where you come in. Because I actually see law enforcement as the best opportunity to make sure that a person is not wrongfully convicted. You are the first responders to the crime. You're the first ones there. You generally follow the case all the way through. Defense attorneys come on generally when someone's charged. Same thing with prosecutors, judges, jurors, even later. But law enforcement is there. And you're the ones that find the leads, and you're the ones that seek the truth. What we have said to defense attorneys, prosecutors, judges about wrongful convictions is that they all have a part. You also have that part. And we want you to understand that in your quest to seek the truth, there are no sides. It's not defense side, prosecution side. The truth has no sides. It's just the truth. And so in pursuing that, you need to question everything. You need to ask yourself, is this the right answer? What can I do to find out if it isn't? And follow that. Don't always have tunnel vision thinking, I've got my suspect. This is it. Because it may not be. You may have the wrong person. You may have the wrong understanding of what even happened. And that's one of the things that you need to understand, too, is by pursuing that, you're improving your credibility ultimately. Because what's the jury or the judge going to want to know, the fact finder? Did you consider everything? And you can say you did. You followed up on this. You followed up on that. Ultimately, that lead didn't pan out, but you considered it. You weren't laser focused on that one person or that one scenario to where you were certain that it had happened and you didn't consider anything else. And that's very important. And it also helps when you have an innocent person, because you may be the one to save their life. And so now Steve's going to talk to you about a case that we had where it isn't even, do you have the right person? It's, do you actually know what happened?
You heard about the concern earlier that the system places greater value on finality than justice, and that is certainly true. It is no place else in this country more true than in Virginia. And the reason I say that is because only Virginia has this 21-day rule of finality, meaning that if you discover unrebuttable proof of evidence on day 22 after the sentencing, the system does not accommodate it. You heard reference earlier to our assistance in enacting the writs of actual innocence back in the, I think that was 2001. And I do have to say that all we did was assist. You heard reference to our working with state political leadership. By state political leadership, I have to tell you that was then ranking Republican Senator Ken Stolley, who chaired the courts of justice for many, many years, who initially hired me back then as counsel to that committee, who was responsible for all of the important pieces of legislation that were enacted back then. He has always been my hero because he has always sought to do the right thing. Unfortunately, the writs of actual innocence for which he was responsible, they were very important because they enabled 20 years worth of wrongfully convicted to have their newly discovered old DNA samples from the case files tested and resulting in numerous exonerations. But the legislation that was written back then only was retroactive. The legislation means that if you discover DNA now after you've been convicted, If that DNA existed at the time of your trial and you could have had it tested, you're out of luck. So we're back to square one. If you don't get it right before those 21 days have expired, then you have no recourse but a governor's pardon, which is always going to be a political thing. Everything Betty Lane says is our method. Question everything. Ask every question that logically should be asked. Follow every lead. For heaven's sakes, keep an open mind. Even when you identify the person you are convinced did it, keep that open mind and follow every other lead, because surely you're going to be asked about it if you don't do it at trial, and it will increase your credibility, as Betty Lane said. If you can't follow every lead, for example, if you can't submit every item of physical evidence to Department of Forensic Science for testing because that is their policy, they will not let you, then be able to explain that you wanted to do that. And as a side note, I'll tell you, you can also include the fact that defense attorneys have an equal ability to ask the Department of Forensic Science to test physical evidence. Few attorneys even know about that. Few attorneys exercise that affirmative investigatory function, but that's something you can include in your answer, that no, you couldn't submit everything, but certainly the defense lawyer could have, because that's what the law permits in Virginia. I also want to encourage you to talk to the defense attorney. When we get involved, the very first thing we want to know from the client and from everyone else is, what are the facts of this case? I don't care if they're good or bad, but I've got to know the facts. And I will always try and talk to the investigator, because I want to know, what should I know? What is my client not telling me? And this also gives you a chance to ask us questions. And together we might be able to work together to answer some of the unanswered questions. The system is adversarial. There's no getting around that. But there should not be anything adversarial to the fact-finding function. We all want to know the facts. What I'm going to show you here is an illustrative case. This is something we worked on a couple years ago. And what the case illustrates is what we're talking about. During the course of an investigation and during the course of a representation or a prosecution, we should all be asking, what questions does this case present? What questions should I, as an investigator or a defense lawyer or a prosecutor, what should I be asking? How can I determine the truth? This case illustrates that, and I'm happy to use this case because the Sheriff's Department in this particular jurisdiction, they really were the heroes here. After the conviction, we weren't involved in the trial, but after the conviction, we got a call not only from the defense lawyer at trial, but also from, I'll just say, law enforcement personnel. They were concerned that an innocent person had been convicted. They were concerned because facts had not been developed or had not been presented at trial, and they asked us to take a look at this case. All right, in this case, the story was a simple one. The young woman, 20 years old, was walking home one December night. She had just left her boyfriend's apartment, and she stopped at a convenience store on her way home where a gentleman offered her a ride. She said she got into the truck. He was driving. He began to drive her home, but suddenly he passed the turn to go down to her apartment. She had her cell phone with her, and she began frantically texting to her boyfriend that she had gotten this ride. The man wasn't letting her out. She didn't know what was happening. The boyfriend started to try to call. Suddenly, the boyfriend gets a text from the abductor saying, I've got your girlfriend, she can't talk, she's passed out. And in fact, at trial, the young woman would testify that while she's frantically texting, the man reaches over with a rag that has some chemical substance on it, and she passes out within 5 to 10 seconds. And that's how the man got the phone. He begins taunting the boyfriend, saying, I've got her, she's so lovely when she's asleep. She wakes up in an abandoned house she's never seen before. She doesn't know where she is. She hears the man texting on her cell phone, taunting the boyfriend. She plays like she's still unconscious until he leaves this abandoned old house and goes out to his car. She escapes, jumps off the back deck, hides in the woods. She texts to the boyfriend that she can't make any sound. He'll find her. The man yells, looks for her, and finally he leaves, and so she makes her way home. She can't call, now the boyfriend has called emergency dispatch. They're trying to reach her on the cell phone, but she explains she can't answer. She can't call 911 because after her last text, her phone had died. She walked home, the police came to her house, and she repeated her story. What happened was that the man was, well, actually, let's get to that. The story begins with the text messages. At 11:32, she's been kicked out of her boyfriend's house, and she starts texting him, "Where should I go? It's freezing." And she says, well, I guess I'll go home, but what if my mom hits me? Can I please come back? At 11:54, she's texting to the boyfriend, "Hopefully she won't stop my ribs." And then at 12:10, she says, "Oh, well, can't type, too cold, and some dude is giving me a ride." This is some dude. This is Mark Weiner, a 55-year-old grocery store manager who had never been in trouble with his life. His crime that night, or his misjudgment, was offering a ride to this young woman. So she says at 12:10, "Some dude is giving me a ride." At 12:18, she ups the story and says, "He tried to get into my pants." At 12:21, we just pulled up. He won't let me out of the car. 1 minute later, 12:22, in car, just past the turn to her apartment. "I don't know where we're going, ... baby."
An important thing to note here is that the boyfriend was not responding. So all this time that she's texting him, he actually fell asleep or something. But this is why she starts ratcheting the story up, because she's not getting any reaction at all from the boyfriend.
Actually, he was trying to call her because the next, 12:22, I don't know where we're going, baby. At 12:23, that's when the narrative changes, and this is the abductor. See, the boyfriend is trying to call. She's not answering the phone. The abductor texts back to the boyfriend. She doesn't have her phone. 12:23. At 12:27, "Sorry, man," responding to the boyfriend, "I can't do that. She's so sexy when she's passed out." A minute later, 12:28, she was a fighter. I'll give her that much. And then at 12:36, the supposed abductor says, "I'll let her wake up before I let you talk to her." 12:41, "She's in my house. She said she was cold, so I'm a warm her up." 55-year-old, that's where I start to get a little suspicious, if I'm not already. At 12:49, you have this plaintive text from the abducted young woman, "Baby." At 12:51, because the boyfriend is still trying to call, "I can't answer. He'll find me." Now, at trial, she testified that at 12:49, she had escaped already and jumped off the porch and was hiding in the woods, and he's trying to call, so she's saying, "I can't answer the phone because he'll find me." She's already in the woods. That's at 12:51. At 12:52, she says, "I'm going out the window. Hold on." So, what this illustrates are the questions that we should have been asking. And the first question we want to ask is, where was the young lady when these texts were sent? She testified that she awoke on the second floor of that abandoned house. That house was on the other side of a mountain in this particular region, and that's important. The Sheriff's Department, at the request of the defense attorney, obtained the cell tower location information and was able to determine, you see at the very bottom, that's where the abandoned house was. You would then go, if you were driving up 250 from that abandoned house, it's a long, long climb up the top of that mountain, then over, and then you get to the apartment building where she lived with her mother. What the cell phone tower and cell phone data told the department, the Sheriff's Department, was that when those texts were sent, supposedly from the abandoned house on one side of the mountain, the phone did not engage with, did not connect with that first tower, which was 400 yards away, 400 feet away. It did not connect with that tower, which was a little bit further up the mountain. Instead, it connected with a cell tower that was on the other side of the mountain near the apartment where the young woman lived. And so those text messages were not coming from the abandoned house, as she testified. Instead, they were coming from the other side of the mountain, closer to that cell tower. They were coming from her own apartment. The truth of the matter was that she wasn't abducted. She made up this story to get attention from a boyfriend, and after Mr. Weiner dropped her off at her mother's house, she began this series of texts pretending to have been abducted. That was a pivotal question, and it was answered. That evidence was not presented at trial. The defense attorney had various experts from the phone company and elsewhere to testify, but because of a procedural failure on his part, the prosecution made what was a proper objection and prevented that testimony and that evidence from going to the jury. So they never heard about which cell tower the texts were coming from. Question number 2 that should have been asked by everyone is, how did the abductor obtain the phone? At 12:22, she says, we just passed the turnoff. At 12:23, it's now supposed to be the abductor. So how did he get the phone? What she said, what she testified to, was that in that short span, the driver turned to her and put this chemical-soaked rag over her. It took 5 to 10 seconds, and then she was unconscious for the next 20 minutes. Okay, we've all seen that, right? In movies, on TV. We know about the chloroform rag. But have we ever asked, does that really work? Should we have asked that in this case? Can you be rendered unconscious within 5 to 10 seconds with a chemical-soaked rag over your face? Well, we didn't know, but we were suspicious, and so we contacted an anesthesiologist who supplied us with an affidavit saying, although it is possible to induce unconsciousness by using certain chemicals, you need first a cooperative patient, somebody to take slow, deep breaths. It takes much longer than several seconds. It takes 5 minutes to 10 minutes. And if you're doing it with a rag, you're more likely to kill the person because it's so concentrated. And that's why when they use this method, sometimes they use it on infants, it's regulated with very precise machinery. He said, but the bottom line is, no, you can't just put a rag over somebody's face and they pass out. It doesn't happen. The answer to that question was no. The next question was, did she give her abductor her phone number? Mr. Weiner had testified at trial consistent with what he said when the police first stopped him the next morning, the morning after the supposed abduction. He said, I dropped her off at her mother's apartment, and not only that, she gave me her phone number. I wrote it down on a matchbook. He said that to the police when he was stopped, and he testified to that at trial. The prosecution cross-examined him on that and saying, we never found a phone number. You know, you're just making that up. And Mr. Weiner did not have anything to present. Well, what we learned when we got involved in the case is that after the vehicle was released, the defense attorney searched it himself, looking for the phone number, and found it, written on the back of the matchbook, just as Mr. Weiner had described. Unfortunately, in the midst of trial, the defense attorney didn't know what to do with that. Question number 5, why didn't she call 911? If she's being abducted, and that's certainly what she was texting about, then why didn't she instead just press 911 and let things take their course? And if not then, when she made her escape and got her phone back, then why not call 911 then? And the answer was, or the testimony was, well, my phone went dead after I sent that last text at 12:52. And here you see the argument from the prosecution in closing argument, asserting the phone went dead after she escaped. There was nothing else after 12:52. So the question is, did her phone die at 12:52? That's her answer for why she didn't call 911. And so the next question, investigatory question for everyone was, well, did it really die? We obtained the phone records for her phone, and we see that not only did it not die at 12:52, she made or received calls at 12:56 for a minute and a half, at 1 o'clock a.m., at 1:05, 1:07, 1:08, 1:09. She was constantly making or receiving calls, I think primarily with her boyfriend, certainly not with emergency dispatch, certainly not the police. Emergency dispatch had left a message for her, in fact, asking her demanding that she call immediately because of the reports that they had gotten. She erased that message. Finally, how was she able to describe the interior of the house? This was her testimony. She had no idea where she was. She had never been in this house before, and that was a compelling argument from the prosecution. There's a question, had you been in that house before? No, I'd never been there. And then the argument, she's never been there before, and she doesn't know where she is. She's never been there. Once we got involved, we retained an investigator to try and determine if this was true. We had a lucky break because this, and we were able to do all this, by the way, because we delayed sentencing continually. We were hired after trial, before sentencing, and so the 21 days had not begun to run. I think we continued the sentencing for about 2 years. This was 2 years' worth of effort. Once sentencing occurred, we knew we were out of luck because of the 21-day rule. But we kept continuing sentencing, and as the case got more publicity, witnesses started to come forward. One young man contacted us from jail, and so we sent an investigator to talk to us, and he said, look, I know this young woman, and we used to hang out together at this old abandoned house that my family had originally lived in. We would go there, underage drink, get high. Yeah, she knew that house well. So we asked, who else used to hang out with her at this house? And he gave us additional names. The investigator ultimately was able to track down other witnesses who we brought forward to testify and to give affidavits that, in fact, she had been there before on numerous occasions. What she had testified to was a lie. All of this we put together in successive motions to set aside the guilty verdict. All of those motions were denied. They were just denied. Sentencing occurred. He was sentenced to many, many years in prison. We continued to assert he is innocent. This is a story that shouldn't be believed in the first place, and the deeper you dig, the more you see that this man is absolutely innocent, but he was sentenced. Before the 21 days had run, the prosecution learned that the young woman had been arrested for drug trafficking and had begun working with another section of the police department, cooperating, and called me and told me this and said, look, this is just one too many straws. It was also true, however, that the prosecutor was running for re-election and was being criticized every single day from every aspect of this community for keeping an innocent man in prison. And so she agreed that she would go in front of the judge with us, and ask that he be released. And he was exonerated. But it took 2 years of effort, and we were able to do it only because the sheriff's department was so concerned about this conviction and the integrity of this conviction. One of the investigators, for example, drove me around this jurisdiction, showing me the different cell towers. And this is an excellent example of how things can go wrong if we don't ask the right questions, and how we can all work together to correct a terrible injustice. Unfortunately, this is too common. We've had many of these cases. They scare us to death because the system and your job should be as much about protecting the innocent as capturing the guilty. It's the truth that matters. It's the facts. Thank you for what you do.
Good morning. As you can see, Mr. Benjamin and I share the same barber. But I say that only half in jest because a lot of what has been said up here today by both Mr. Benjamin, Mr. Porte, Mr. Adams, we're singing off the same sheet of music. We have no desire to see the innocent get convicted. The first thing I'm going to say is I'm going to use the term erroneous convictions rather than wrongful convictions. And I do that for a number of reasons, primarily because of one of the studies that I'm going to talk about. The person who conducted this particular study, that's the term he used. And he used that term because in 99.9% of the time, there is no intentionality. There's no intention to convict somebody who is innocent. I'm not going to say it never happens. But it happens so infrequently that I'm going to use the term erroneous convictions rather than wrongful convictions. But with erroneous convictions, justice is denied. It's denied to the person who's charged. It's denied to the victim. It's denied to potential future victims. If we have somebody who's committing serial crimes and that person is not held responsible, we've got the wrong person, there are going to be more of other future victims out there as well. And of course, the society is going to be denied justice as well. So we do not want to see wrongful or erroneous convictions. And law enforcement particularly doesn't want to see erroneous convictions. I mean, we've all been sworn to uphold and defend the Constitution of the United States and the Constitution of Virginia. And there's a particular rule of professional conduct that regulates my profession of prosecution. It's Rule 3.8 of the Rules of Professional Conduct. And there's a number of comments that follow that particular rule, and it talks about, it basically expounds as to what that rule particularly means. The very first sentence in the very first comment following Rule 3.8 says that a prosecutor has the responsibility of a minister of justice, which sounds pretty odd because both Mr. Adams and Mr. Benjamin have talked about the adversarial system, and that's what we have in Virginia. That's what we have in the United States. We've had that for hundreds and hundreds of years coming down from the common law of England. And an adversarial system is designed to find the truth, but is that the most effective way? Well, it's the way we have. It's the way we're going to have. It certainly, when we're adversarial, it gets our competitive juices going, as Mr. Adams referred to, and we want to win. And so if you conflate winning, from my perspective as a prosecutor, with gaining a conviction, very bad things are going to happen. I'm not the only prosecutor in the Commonwealth of Virginia who refuses and refused to keep conviction rates, because bad things will happen when you have conviction rates. Because now if you've got a 90% conviction rate, you want to make it 91. You want to make it 92. You always want to be better at it. But is that justice? I know the Commonwealth's attorney for Newport News has basically said he would fire any assistant who kept conviction rates or looked at conviction rates, because that makes you do bad things and go down the bad paths. So while I'm not going to tell you there aren't the Mike Nifongs of the world, he was the Duke LaCrosse prosecutor who deliberately went after people who he knew were innocent. And he did it to basically get reelected as prosecutor. We have an ethical obligation, we have a moral obligation as law enforcement officials to root out those folks. And I had a couple in the Lynchburg Police Department over the course of years where we had to basically root them out because they had gone down the wrong path as far as our adversarial system is concerned. And we've got to get those folks out of our business because when they want to convict, regardless of what the evidence is. I mentioned a little while ago the Constitution. We swore an oath to uphold and protect the Constitution. It was interesting. There's a case called Crawford versus Washington. I'm not, those of us who are attorneys or criminal defense and criminal prosecution attorneys are very familiar with this particular case because it changed the law dramatically as far as hearsay evidence is concerned. But I remember reading that particular case back in the mid-2000s and coming across a line written by Justice Scalia, basically saying that constitutional protections provide procedural rather than substantive guarantees. And I started thinking about that, and I was like, what? And I knew he was right, because we as human beings cannot, in no way can ever know for sure who is guilty and who is innocent. Only God knows that. We don't have a substantive right to justice. There's nothing in the Constitution that says only the guilty shall be punished and the innocent shall go free. We haven't said procedural rules, and we have to be steadfast and true to those procedural rules. So whether we're talking about exculpatory evidence, whether we're talking about the right to cross-examination, whether we're talking about the right to compel witnesses in your own defense, those are the procedural rules that we have to follow in order, as Justice Scalia said, in order for us to come with a just result. Only when we have just procedures can we come up with a just result. And even then, as has been pointed out, we're human, and even with our just procedures, we're going to have some erroneous convictions. So, what have been some of the traditional explanations for erroneous convictions through the years? Mistaken eyewitness identification, false confessions, tunnel vision, which is also known as cognitive dissonance. You know, I've always used cognitive dissonance in my practice as a prosecutor. Cognitive dissonance is basically a psychological phenomenon in which if you come to a conclusion, then basically the facts that you hear after that particular conclusion, it may be just the initial conclusion, but if you hear those particular facts that resonate and reinforce that conclusion, you will hear those. If you hear facts that don't resonate and conform to that conclusion, you will put those aside. That's why, as a prosecutor, I always really focused on opening statement, because that was where I was using the phenomenon of cognitive dissonance to get the jurors to hear the evidence that supported that particular conclusion that he reached in an opening statement. But it can be bad. And it can be bad for law enforcement to get in that tunnel vision, because then you only look at the facts that support your initial conclusion, and you don't look at the facts that don't support that initial conclusion. We had another traditional explanation was perjured informant testimony, forensic error, which is basically whether it's junk science or whatever it might be, prosecutorial area, which includes Brady violations, the exculpatory evidence that were not being turned over for whatever reason it might be. Bottom line is we as prosecutors are responsible for whatever evidence that you as law enforcement officers know, even if we don't personally know it. And so a lot of times with exculpatory evidence, it's something that's I've talked to law enforcement officers and I said, look, you've got to turn over all this stuff. And the response I've gotten on a number of occasions is, but that hurts our case. Yes, you got it. It hurts our case. That's why you have to turn it over. And because, again, with this adversarial system, we tend to get competitive and we don't turn over that particular evidence. We've had instances in the past where law enforcement did not turn over exculpatory evidence to the prosecutor because they deemed that it was inadmissible. No. As far as law enforcement, as far as prosecutor, law enforcement, we don't make that call on determining whether it's exculpatory evidence. We turn it over. And then inadequate defense representation is, again, been one of the traditional explanations for erroneous convictions. But as this study I'm going to talk about real briefly has come to basically started asking the questions, are these actual explanations as causes of erroneous convictions, or are they just correlations with erroneous convictions? And so this year, a study has come out by John Gould, who's a professor at law at American University School of Law. And as a result, he compared 460 cases of erroneous convictions with near misses. Now, what is an erroneous conviction? An erroneous conviction is basically where there is a really strong indication of factual innocence, not legal innocence. Legal innocence is basically case gets reversed because evidence should not have been admitted. It gets reversed because the prosecution didn't turn over exculpatory evidence. Professor Gould looked at cases where there was exoneration due to DNA, science, or there was a formal statement of innocence by the judge, by the prosecutor, whatever it was, so that he had cases of erroneous convictions where innocent people, factually innocent people, were convicted. And he compared these with about an equal number of near misses, cases where the evidence basically was very similar, but the person was ultimately acquitted or the charges were dropped against him. And the bottom line is what he was looking for in comparing these cases was basically if you can identify the cause of erroneous convictions, then you might be able to prevent erroneous convictions. Comments that Mr. Benjamin and Ms. Deporte have been bringing to our attention. Prevent them from happening in the first place. So, in asking these questions, the bottom line was that he asked two overarching questions. What factors explain why innocent suspects are erroneously convicted in certain cases but acquitted or have their charges dismissed in other cases? And what policy interventions will help the criminal justice system get it right in the future? So, as a result of comparing these 460 cases, he came up with a number of statistically relevant factors to the point where he can actually predict within 91% if these factors exist that you may very well have an erroneous conviction. One is the punitive nature of the particular state. As we're well aware that we have certain states where they're basically more law and order than other states. Law and order in the old, Nixonian sense of law and order. And basically the community is pressuring law enforcement to find somebody guilty of this particular heinous crime. So that is one particular factor. Another factor that is statistically relevant as far as predicting erroneous convictions is tunnel vision, something we've talked about over and over again. Another factor is the age and criminal record of the defendant. The younger the defendant is, the more likely this person may be unemployed, may not have an alibi, may not be able to assist in his own defense. Mr. Adams talked about forgetting about his particular witness for a period of time, and he was young. And is that an explanation? Perhaps. I can't speak about his particular case, but Professor Gould has found that the age of the particular defendant, the younger they are, the more likely that there's going to be result in an erroneous conviction. Lying non-eyewitnesses. These are the jailhouse informants, the ones who are lying, that are basically, we cannot corroborate what they're saying. Forensic error. This is not so much the junk science. This is the misinterpretation of the data or the testing, or the testimony is not coming out exactly as it ought to. And I can think of a particular case that I had where I did have some very good evidence, and we had overwhelming evidence of this person's guilt. But the forensic person who testified did not get it right. And we basically had to go back before the court and make sure that the court was aware of this particular fact because she had mistestified as to what her evidence had come up with. Intentional misidentification by eyewitnesses. This sounds sort of odd, but there are some eyewitnesses who will intentionally misidentify because of some animosity towards this particular defendant. If we can identify those particular people, we can basically eliminate that from happening. It's the mistaken eyewitness identification is more difficult to root out. And then we have poor defense lawyering. Professor Gould found that unlike the representation that Mr. Benjamin is giving, there's a lot of defense attorneys who are either through the fact that they're young, they're brand new out of school, they haven't had no mentoring, they are overworked, they're overwhelmed with the functions that they have, that they're not able to keep up with it. What they found was statistically non-relevant was the race of the defendant, informant testimony. I'm not talking about the lying jailhouse informant, I'm just talking about informant testimony as a whole. false confessions, police error, the type of defense attorney, whether it's a retained or court-appointed attorney, public defender, that had no statistical relevance as far as the rate of erroneous convictions, and interracial eyewitness identification. Now, having said that, you know, I'm basically going to tell you that, you know, there are the false confessions, the police error, race do appear in both the erroneous conviction category as well as the near miss category, and they appear by a rather large proportion. But Professor Gould has been able to determine that rather than being predictors of erroneous convictions, they may just explain why these innocent people are in the criminal justice system in the first place. One of the other things that he found was that erroneous convictions and failed prosecutions, and he defined failed prosecutions as where the guilty or actually get acquitted, they have many of the same sources. And the number one source of a failed prosecution was insufficient evidence. And that's, of course, where we rely so heavily on law enforcement to come up with the sufficient evidence to go forward with this particular case. But he's also concluded that if we can prevent one from happening, one side, the failed prosecution side, that we can also reduce the number of erroneous convictions. So where does that leave us as far as his policy recommendations? Number one, he's got a number of recommendations dealing with eyewitness identification. And of course, the number one is going with the double-blind method, where the person who is showing the show up, the lineup, and I shouldn't say show up, the lineup, it does not know who the particular suspect may be, because there are all sorts of nonverbal communication that goes on or can go on that will point out and highlight who that officer thinks might be the suspect. Instructions to the witness, instructions such as the suspect may or may not be in this lineup is very important. Instructions that I'm not, and where if you're going with the sequential model, that you don't say things like there will be 15 photographs, I want you to pick out somebody. Because at some point, if there are only 15 photographs, the person is going to come to the conclusion that it must be one of these 15, so they got to pick somebody out of these 15. So that's the selection of fillers. Make sure that your fillers match up with your suspect to some degree or another. I was actually a filler in a rape case one time. Scared the daylights out of me. What if the victim picked me out? But I did happen to look a lot like the suspect. You know, this is an incredible, crucial one, gauging the witness's confidence level immediately. Because as time goes on, they're going to basically build and support their initial conclusion. Written threshold for lineups. Actually have a written statement as to why you're going through this particular lineup procedure and why this particular suspect is in that lineup. There's a lot of debate whether sequential or simultaneous are the more accurate. There's a number of studies that say that sequential are. There are a number of studies that say simultaneous are. That one is still basically waiting for more psychological evidence. But we in Virginia have adopted a model policy of having sequential lineups. But the studies are still coming in as far as that's concerned. Videotape interrogations. Training on tunnel vision, or just being aware that tunnel vision, you may be suspect to tunnel vision, because we all are suspect to tunnel vision. Checklists for investigations. As Professor Gould talked about it, pilots with hours and decades of experience, before they take off in a plane, they go through the checklist. Even though it's the 5,000th time that they've flown a particular plane, they go through a checklist. Why? Because you want to make sure you don't miss anything. And we needed to do that with law enforcement as well. Forensic testing as early in the investigation as possible so that we have the science to support our particular investigation. I realize that's a problem. We have a lot of problems as far as money is concerned, and we're going to talk about that here in a second. But as early as you can get that forensic testing done, the better it is. Have prosecutors assigned to law enforcement, actually working in your office, working in the police department office, working on these cases as they are developing, rather than being handed a file after charge has been placed. And that gets to the second one, senior prosecutors assigned to intake. You know, in Virginia, we are one of 3 states where prosecutors don't necessarily have to sign off on a warrant. This is crazy. We don't sign off. You guys can go and get a felony warrant. You can get a rape warrant, murder warrant. The only warrant you can't get without our permission is a capital murder warrant. We don't have to sign off on anything. 47 states require a prosecutor to sign off on a warrant before that gets done. And basically, we get handed this particular document, this arrest warrant, and we have not signed off on it at all. Senior prosecutors assigned to intake, they may also have standards that are, I'll tell you, my standard has always been not probable cause. Probable cause is a very low bar. My standard is, can I probably prove beyond a reasonable doubt this person's guilt? If I can, then I authorize the charge. If I can't, I'm not authorizing the charge. That is a different standard than mere probable cause. Open file discovery by prosecutors. Open file is basically coming as of 1 July of 2020. Not completely, but pretty close to it. Our rules of discovery are going to be greatly expanded as of 1 July. But open file discovery by defense attorneys. Professor Gould found that in less than 30% of the cases where there was a court-appointed attorney was the defense attorney taking advantage of the prosecution's open file. And I've had a number of cases over the course of years by good attorneys who have not taken advantage of open file, or have looked at it in a cursory fashion where they have no idea what my file really says. And reducing caseloads by both prosecutors and defense attorneys. A lot of the problem is not because we are bad people, whether on the prosecution side or the defense side. A lot of the problem is where we're being worked to death. You know, it's interesting. It's just in the last couple of, maybe last year, that the General Assembly has come to realize, because of the introduction of body-worn cameras, that, wow, we've always done the criminal justice system on the cheap. And we have come to realize that our caseloads are way over what they ought to be. And it's not just body-worn cameras. It has been like this for decades. And it's just now that the Virginia General Assembly is coming to this realization. So what else is going on? I mean, the International Association of Chiefs of Police, I went to their website. I Googled to see what they went on. I went IACP, wrongful convictions. I came up with this particular website. They have, in conjunction with the Innocence Project, particularly the Ohio Innocence Project, have come up with a number of videos dealing with confirmation bias, memory malleability. You know, people who have suffered trauma don't remember things the way that you as law enforcement do, because the brain works totally differently when a person is under trauma. They have videos on eyewitness identification, false confession, tunnel vision, implicit bias, and lie detection and demeanor evidence. You know, I know that there's a particular group out there who's been teaching how to do interrogation and basically reading the demeanor of people as far as whether to tell whether they're lying, whether they cross their arms, or whether they have a nervous tic or whatever, and that's supposed to be an indication that they're lying. No. Just as we all grieve differently, we all react differently to pressures. The National Sheriff's Association, the National Sheriff's Association has a webinar coming out next month dealing with multidisciplinary review teams, looking at bad things that have happened, whether it's erroneous convictions or death in custody or whatever it might be. And this is a free webinar that's coming up next month, being put on by the National Sheriff's Association. So we in law enforcement are very aware of this, and we want to make this go away, because one erroneous conviction is one too many. So what do we do in response? We foster a climate of compliance within our offices as prosecutors. We train our prosecutors. We train our law enforcement officers. We talk to our law enforcement officers, as we're doing here today. We do the collaborative training so that we can end, to the best of our ability as human beings, erroneous convictions. So, thank you.
Thank you very much. What a valuable information we can take back to our respective agencies. So thank you again for being here. We appreciate all the hard work you've put toward this. Now it's time for a coffee break, and sponsored by Verizon. So enjoy your time at the coffee break and be back in here promptly to begin at 10:45. Thank you very much.